Welcome. I'm Sebastian Mahfood, and you're listening to WCAT Radio, the on-air wing of En Route Books and Media, bringing you the dulcet sounds of Catholic wisdom.
Welcome to the third episode of Living the Gospel of Life. I'm your host, Leticia Velasquez, and in today's show, I'm going to focus on the Supreme Court of the United States. It's July 1st, 2018, and two momentous things have happened this week regarding the pro-life movement with the Supreme Court. So in order to have proper context to explain these to you, I'm going to give you a brief history of the pro-life decisions or anti-life decisions in the Supreme Court of the United States. But let us begin with a prayer from the end of Evangelium Vitae by Pope St. John Paul II. In the name of the Father, and of the Son, and of the Holy Spirit. Amen. O Mary, bright dawn of the new world, Mother of the living, to you do we entrust the cause of life. Look down, O Mother, upon the vast numbers of babies not allowed to be born, of the poor whose lives are made difficult, of men and women who are victims of brutal violence, of the elderly and the sick killed by indifference and out of misguided mercy. Grant that all who believe in your Son may proclaim the gospel of life with honesty and love to the people of our time, obtain for them the grace to accept that gospel as a gift ever new, the joy of celebrating it with gratitude throughout our lives, and the courage to bear witness to it resolutely, in order to build together with all people of goodwill the civilization of truth and love, to the praise and glory of God, the Creator and Lover of life. March 25th, 1995. That's when John Paul wrote this. And I'm going to read to you a chapter in Evangelium Vitae, as I try to do every week, so you know how relevant this encyclical is 23 years later, and how prophetic it was, very much like Humanae Vitae, very prophetic about the consequences of disobeying God's moral law in society. So John Paul starts in chapter 68 by quoting Acts 5, verse 29, which says, "We must obey God rather than men." So outlining the relationships between civil law and moral law. You know, many times Catholics are told to leave our religion at home. The left wants us to believe as we want to believe, but to leave it at home and not to interfere with society. Well, you know, there's an awful lot of governments that wanted Catholics not to bring their conscience into the marketplace, most notably communism, where Pope John Paul II enacted a revolution through empowering people to bring their faith into the marketplace. Certainly there were many brutal dictators who tried to suppress the Catholic Church, from the Reign of Terror in France after the revolution to very many brutal dictators throughout the world. Anyone who wants absolute power does not want Catholics who know their faith, who live their faith, because the freedom that we have as children of God is something that will not bow to any political power, because the moral authority of God always supersedes it. So let me read what John Paul has to say in chapter 68 of Gospel of Life. One of the specific characteristics of present-day attacks on human life, as has already been said several times, consists in the trend to demand a legal justification for them, as if they were rights which the state, at least under certain conditions, must acknowledge as belonging to citizens. Consequently, there is a tendency to claim that it should be possible to exercise these rights with the safe and free assistance of doctors and medical personnel. As an aside, I'm going to mention the right to privacy, which has been used to justify abortion, has been enshrined in many minds and in a lot of laws in the United States as a right to abortion. So he's talking about the state demanding a legal justification, as if somewhere in our founding documents the founding fathers wanted to justify abortion. And you know that abortion would have been completely unthinkable to them. So I continue with Pope John Paul, Evangelium Vitae. It is often claimed that the life of an unborn child for a seriously disabled person is only a relative good, according to a proportionalist approach, or one of sheer calculation. This good should be compared with and balanced against other goods. It is even maintained that only someone present and personally involved in a concrete situation can correctly judge the goods at stake. Consequently, only that person should be able to decide on the morality of his choice. The state, therefore, in the instance in social harmony, should respect this choice, even to the point of permitting abortion and euthanasia. So what that means is that when the left says that abortion should be decided between a woman and her God or a woman and her doctor, he said that that is absolutely untrue. It is moral relativism, what Pope Benedict called the dictatorship of moral relativism, that my truth and your truth are different, and we each get to decide our truth. And there is really no one who believes that completely, because if you can take that to its logical conclusion, all right, I don't have a right to live in this house by myself. Anybody who wants to could walk in the door and decide to set up shop in my house and to live in my house, to take my food, and to kill my daughters and violate them, to do anything they want, because after all, I think that it's wrong, but they may not. They may think that they need to come and take over my house. And there's many, many other ways to find that people who say they believe in relativism really don't mean it. They just mean they believe in relativism when it's convenient for them, when they want to change God's moral law to suit their purposes. And Pope John Paul makes it very clear that the right to life comes in Evangelium Vitae. The right to life comes from God and God alone, and only God can take it and be morally justified. God is the author of life. He gave us life, and he can decide when it begins and when it ends. And any other decision must be subjected to severe moral scrutiny, and only in very rare cases can another one's life be taken. In the Catholic belief, the only two times a life could be taken would be if a war is justified, the just war theory, and in self-defense. Some people have said that the Catholic Church teaches against capital punishment. The Catholic Church teaches that capital punishment is licit. The state does have the right to take the life of a criminal who's been through due process. However, Pope John Paul clarified that by saying, with modern methods of incarceration, it's almost never necessary to take for capital punishment. So those two aside, let's just focus on abortion here, and we're going to go through the Supreme Court decisions which have led to the current situation in the United States. The United States is one of 4 countries in the world, including North Korea and Canada and China, which permit abortion throughout all 9 months of pregnancy. So we have a very unique situation, and it's very important that we understand that this judgment was brought about by a slow and steady work of a cabal of pro-abortion doctors and activists who knew that if contraception were approved, yes, if contraception were approved, that abortion would follow. In another broadcast, I'm going to cover the history of Margaret Sanger. Many of you know that she was the founder of Planned Parenthood, but she didn't start with Planned Parenthood. In 1916, she opened her first clinic in Brooklyn, New York, called what was called the Birth Control League, and she was giving out birth control to immigrant women, of which her mother was one. Her mother was an Irish immigrant who died, as Margaret believed, as complications of having too many children, probably a combination of poor medical care. But anyway, so Margaret was determined to help women with birth control, to be in control of their bodies. That sounds a familiar phrase. And her Birth Control League, unfortunately, aligned itself with eugenics in deciding that some people are more worthy of life than others. That's a topic we covered last week. All right, but she definitely located the Brooklyn Clinic in where my Italian, Irish, and Polish ancestors were coming in from Ellis Island. So it's no mistake that she was in the tenements, and she went door to door to convince Black and Southern European, Eastern European, and other women, especially, to limit their family size. It's always been an issue of the left to make sure that the poor don't reproduce so much. Let me give you a little preview of one of our current justices to give you an idea of where the court has leaned on these issues. Justice Ruth Bader Ginsburg said, at the time Roe was decided, there was a concern about population growth, and particularly growth in populations we don't want to have too many of. And it's very interesting to note that 90% of abortion mills are within walking distance of minority neighborhoods. So there's always been a eugenic bent to population control and abortion. And anyone who doesn't see it isn't looking closely enough. So let me go back to the short history of birth control. Birth control, contraception has been around for all the ages. I mean, there's evidence that there were condoms in ancient Egypt. All right, so it's something new. Neither is abortion. Abortion has been done in many ways throughout the world. But let's talk about the churches and their views on abortion and birth control. First of all, birth control was outlawed by every single religion until 1930. Yes, up until 1930, contraception of any kind was considered immoral, even among married couples. Then in the Lambeth Conference, which is among the Episcopalians in England, in 1930, birth control was approved for married couples. There seemed to be no reason to regulate, to not allow regulation of birth in married couples in their point of view. And the tragedy of it is that they opened the Pandora's box. The Episcopal Church only meant to allow married couples to do what they thought was reasonable, to limit the number of children that they would have. Unfortunately, it never stays there. It always blooms beyond what you thought it was going to go to. So what happened is, little by little, other mainstream Protestant churches and then the Jewish congregations approved contraception for married couples. Again, what's the problem with that? They're married. They should be able to regulate birth. The Catholic Church is not against regulating birth as necessary if there are grave reasons, but they do not approve of contraception. As we know, in 1968, Humanae Vitae was issued by Pope Paul VI and caused a great deal of controversy in society and the Church by saying, no, artificial contraception is never illicit. And the only type of birth regulation is done through natural means, as in natural family planning. That's not the rhythm method. But again, that's fodder for another show. So in this atmosphere that the pill came out, I believe it was 1960, the contraceptive pill was developed by Dr. John Rock, believe it or not, a devout Catholic from Massachusetts, in the lab in Worcester, only an hour north of here. But that's another issue for another time. The history of birth control runs through Connecticut very strongly, though, I'm ashamed to say. There have been advocates from New York mainly for birth control since the 30s, when a birth control clinic was established in Waterbury, Connecticut, which was a big mistake by Margaret Sanger's group. It was birth control at that time was against the law, if you can believe it, in Connecticut. And a group of Catholic priests, Irish Catholic priests, God bless them, young firebrand Irish Catholic priests, went to the police department in Waterbury. And if you know anything about Irish Catholics in America, the police were very much Irish Catholic in those days, still are. And the police were warned by the priest that this was illegal and conducted a raid and closed down the clinic. By the way, the actress Katharine Hepburn's mother was very involved in this particular action. So from the 1930s, when this clinic was raided and closed, to 1965, birth control was illegal in some states, which included Connecticut, Massachusetts, and it was severely limited in many of the other states. So I'm going to get to the first Supreme Court decision regarding birth control. In 1965, Griswold versus Connecticut decided that married people have a right to use contraception, very much like the Lambeth Conference in 1930. So it took 35 years for a decision of the Episcopal Church to be enshrined in national law. All right, but believe me, culture sped up a lot faster after this. And don't forget, the pill had been approved 5 years ago, so it's very likely that a lot of couples were using the pill without church authority, as most Catholics are using artificial contraception in defiance of Humanae Vitae. According to a pro-choice website, it essentially paved the way for the reproductive privacy and freedoms we have today. You see, many people were opposed to Humanae Vitae, Pope Paul VI encyclical on contraception, because they said contraception has nothing to do with abortion. But the pro-abortion side that were on this website that I was reading knew that if you approve birth control, abortion is soon to follow, that birth control and abortion are just part of the same continuum. From the Catholic point of view, it is saying to God, you may not have control over my body. This is my body. The woman is saying to her husband, to whatever lover she's involved with, this is my body and I don't care. I am going to do what I want to do with my body. Interesting note here. What does Jesus say in the Mass? What does the priest say in Jesus' name in the Mass? And what did Jesus say to the disciples at the Last Supper? This is my body. So Christ gave us his body all right, to save us from our sins, to bring us to heaven, and to be intimately close to us, within us, when we receive Holy Communion, as I did earlier today. But a woman who is contracepting, or a couple, because many times it's the couple's decision, is saying, oh no, this is my body, God. You cannot give me a child at this time. I'm saying no to the greatest gift that God can give a married couple. So anyway, Griswold versus Connecticut. A little bit of the background here. Estelle Griswold was the executive director of Planned Parenthood of Connecticut. And she, with Dr. C. Lee Burton, who was the chairman of the Department of Obstetrics and Gynecology at Yale Medical School, opened a birth control clinic in New Haven to challenge Connecticut's constitutionality. All right, so the entire reason for opening the birth control clinic was not to dispense birth control. It was to start the ball rolling, as they say, legally. So they knew that it was against the law. They willfully broke the law, and they were both very prominent citizens, so they knew what they were doing. They were both very educated. So they knew that by breaking the law, they would be arrested, and they were. The clinic was closed after 9 days. They were arrested and eventually fined $100 each by the appellate division of the circuit court. But that led to a 1965 decision. So this birth control clinic, I believe, was in 1961. So it took 4 years for this to wind its way up the court system. And don't make any mistake. These people know the Connecticut area, the New England area is liberal, so that the higher courts will be liberal, and this will make its way to the Supreme Court. So Griswold versus Connecticut established rights for married people to have contraception. Big deal, right? How does that influence the sexual revolution? Just wait. In 1972, a mere 7 years later, abortion activist Bill Baird gave a talk at Boston University. Supposedly, the students had petitioned him to give the talk. He was well known as a pro-abortion activist and contraception activist. He gave out Delphin foam, contraceptive foam, at Boston University, and a condom to a young 19-year-old unmarried woman. Now, at this time, condoms were legal because they were considered protection against sexually transmitted diseases as well as contraceptive. But the Delphin foam's only purpose was as a spermicide, to kill sperm and act as a contraceptive. Did not provide any benefits to protecting the young woman from STDs. So obviously Bill Baird got arrested and he filed appeals, and the decision was called Eisenstadt versus Baird, 1972. Which extended contraception rights to unmarried couples a year later. This is a very important decision because 1 year later, this decision was quoted 6 times in Roe versus Wade, because the basis of both of these decisions was, well, a couple deserves privacy. First, it was a married couple. Who could disagree that a married couple doesn't want the government in their bedroom, right? Sounds pretty reasonable. It's just between them. How's it going to affect anybody else? Well, it did, because 7 years later, all of a sudden, any couple, no matter how loosely the ties between them, is going to earn the same privacy, the same right to privacy, which really doesn't exist anywhere in the Constitution. But now it's been made a precedent. What's the importance of precedent? Well, it's something you refer to in further decisions. A precedent is something you can say, well, it was done before in American law, so therefore I've got a right to say this. So this Eisenstadt versus Baird was quoted 6 times in Roe versus Wade, which I'm about to get into. But I'm going to give you a little personal aside with Bill Baird. Growing up as a Catholic teenager on Long Island, Bill Baird was infamous for his abortion clinics, and for every time there was a pro-life protest or demonstration, he would come along with a car full of women shoving hangers at us and screaming about getting our rosaries off their ovaries. He was obnoxious. He was in everyone's face. And when I started a pro-life club in my Catholic high school, Our Lady of Mercy Academy, at 16, my friend and I both had a mutual dislike for Bill Baird because he was very out there. He would go up to women on the pro-abortion, pro-life side and tell us how ugly we were and how no one would ever want to have babies with us anyway. We were fat, we were ugly, we were losers. So, he got very personal. So needless to say, our animus towards Bill Baird bound us together. Well, run the clock forward another 12 years, and I'm married pregnant with my first child, and I live near Hempstead, Long Island, where Bill Baird's notorious clinic is. And I find out to my horror that my very good OBGYN, a wonderful African man, was down the hall from Bill Baird in the same office building. So the place where I used to hold picket signs praying outside the abortion clinic, I was walking past, obviously pregnant, so I had to reassure all the people praying the rosary there that I wasn't going to Bill Baird's clinic. My doctor knew of my animus for Bill Baird and told me stories about him. That one time Bill had his doctor, Bill wasn't a doctor, had wounded a woman and she was bleeding profusely, and they went running down the hall to recruit my doctor to fix it, and he refused because he was afraid, I believe, of being sued. But he knew my animus for Bill Baird, and when his clinic closed several years later, he was still seeing me for other births, and the doctor said to me, "So, you happy to hear that Bill Baird's place is closed?" And I said, "Well, I'm praying for him to get to heaven and convert, but closing his clinic is certainly a good move in the right direction." And some years later, I was going to dinner in Northport, New York for my anniversary, and there was Bill Baird with a bevy of women around him in a local restaurant. I'm ashamed to say I did not greet him with love that day, but neither did I eat in the same restaurant. But we won't go into that. So anyway, Bill Baird has always been a contraception activist because he knew that where there's contraception, there's abortion. And he made a lot of money out of abortion and made fame with two other Supreme Court cases later after Eisenstadt versus Baird, which are also expanding the right to contraception. All right, so let's go to Roe versus Wade and Doe versus Bolton, the infamous decision that's on everybody's lips nowadays, now that Justice Anthony Kennedy has announced his retirement from the Supreme Court of the United States. Why is Anthony Kennedy so important? Well, people have called him the most powerful man in the world. And why is that? Well, number one, he wasn't elected, and he had no term limit, so he could stay for life. Number two, the Supreme Court is divided with 4 pro-life justices: Justice Clarence Thomas, Justice Samuel Alito, Justice Neil Gorsuch, who was just appointed by President Trump last year, and Thomas, Alito, Gorsuch, and John Roberts. These are 4 justices who, I believe they're all Catholic except Neil, who will vote for life. Then there's 4 pro-abortion justices. We have Sonia Sotomayor, Ruth Bader Ginsburg, Elena Kagan, and Stephen Breyer. So they are absolutely against the right to life. And then we had Justice Kennedy, who I heard a rumor was a daily communique, was a believing Catholic, but Kennedy would vote back and forth. His record was very spotty. He was the swing vote of the Supreme Court. There were some times that he would vote against abortion, other times he'd vote for it. He voted for gay marriage. He voted against, well, we'll get into Planned Parenthood versus Casey. We'll get into that later. But Kennedy held the power because you never knew which way he was going to vote. So since the other 4 on either side were entrenched, Kennedy was the deciding vote of many of the Supreme Court decisions. Everybody held their breath to see how Kennedy would vote. So some people say that President Trump made an offer he couldn't refuse, made him a sweet deal to leave in time. And unlike many people in the conservative side, I wasn't scandalized by that because it is a good thing that Kennedy's leaving when he can be replaced, hopefully with a solid constitutionalist, somebody who does not find an erroneous right to abortion in the Constitution or even a right to privacy, another construct of the Supreme Court. An originalist believes that we are trying to follow the intent of the Founding Fathers who wrote the Constitution in 1787, that we believe that our system is based on the rule of law and that we must interpret the law as written. You know, somebody on the left who believes the Constitution is a living, breathing document finds anything they want in the Constitution, anything that's following the ways of the times, the culture of the times, and that's where you get some pretty crazy decisions, as we'll see. I'm not an expert in the Supreme Court, but I'm trying to give you an overview so that when you hear things in the news, you know what to believe. So anyway, it's pretty clear that Bill Baird and Estelle Griswold were activists who were trying to move the needle towards abortion. There was a cabal of pro-abortion people who were working for that decade of the 60s, probably before that, and 70s, to have the situation where we practically have abortion on demand throughout all 9 months of pregnancy. All right, I will get into specifics of that now. So Nora McCorvey was a single woman in Texas who was pregnant and was unable to obtain an abortion. So Sarah Weddington, an attorney, a pro-abortion attorney, grabbed her case and used it for the Roe versus Wade decision. Ironically, Norma never had the abortion. She had her daughter, and she has passed away recently. She worked after this Roe versus Wade, where she was the poster child for abortion. She worked in many abortion clinics, and then eventually, through the prayers and faithful witness of many beautiful pro-lifers, became pro-life and became a Catholic. I met Norma McCorvey a few years ago at the Dubliner, the pub where the pro-lifers meet the night before the March for Life, and I asked her if she was going to the march. She said in her Texas accent, "No, honey, I'll just stay in my hotel room and pray the rosary for y'all." I believe that in her humility, she was embarrassed at what she had done, that she had participated unwittingly. I think that she was used and they took advantage of the fact that she knew what she was doing. But she remained a faithful Catholic till she died a few years ago. And if you look up, you will see a beautiful video she did on Priests for Life website, I believe, saying how she was spending the rest of her life to overturn Roe versus Wade. Her name in the decision was Jane Roe. It was a pseudonym for her, but Norma McCorvey was the name of the original complainant. And Sandra Cano was Doe. And she communicated with me one time regarding my group, Keep Infants with Down Syndrome, who are fighting for the rights of children with Down syndrome to be born, because she had a handicapped, I believe it was grandchild, and she felt very strongly that we were doing the right thing. And she also became a pro-life activist. So Sandra Cannon and Norma McCorvey, who were the Jane Roe and I believe it was Jane Doe of the abortion decision in 1973, January 22nd, 1973, are both realized that what they have done is wrong. And even though at the time they probably didn't have full informed consent, they were convenient. Let's put it that way. So the decision Roe versus Wade was upholding in the lower court decision, which said there was a constitutional right to privacy and liberty. Privacy and liberty is being interpreted as meaning a baby in the womb is private. It's within the mother's body. So the woman has liberty to do whatever she wants with that baby within certain parameters. So privacy protects the woman from the government giving her directives on what to do with the child in the womb, and the liberty gives her permission to do what she wants with it, i.e. kill it. Now, unfortunately, that does not declare that baby, that fetus or embryo, depending on the stage, has any legal rights at all. And it was acknowledged in the Roe versus Wade decision that if science advances, and we've advanced quite a ways since 1973, to determine that a fetus is a living human being with complete set of DNA, completely independent of the mother. The baby needs the mother for at least 22 weeks in the uterus, just as an infant needs his or her mother for food and clothing and shelter and in hygiene when it's born. And many of us need a lot of help as we get elderly and die. And my special needs daughter needs me more than a typical person. I mean, human life is nothing if not helping one another and depending on one another, especially those we love. But in that decision, a baby's dependence on the mother proves fatal, right? And the mother has absolute power to do with that child as she wishes. So it's a very sad day in America that this was handed down. And Justice Blackmun was responsible for the majority decision. And he actually didn't write a lot of the majority decision. He gave this to a student, a clerk of his, who was from Harvard. He had graduated Harvard, as many ambitious young lawyers do. And during the summer of 1973, when the clerk was doing research for the decision, he looked at a book by Dr. Larry Lader, about a pro-abortion book. And he was able to get a lot of his misinformation through Dr. Larry Lader's book on abortion. So you took a young man with an agenda who was doing the writing for Henry Blackmun, who, by the way, had a daughter who did have a baby while she was in college, got married, and divorced a short time after. So this is the point of view of the justice who gave the opinion on Roe versus Wade. Justice Harry Blackmun said, the Constitution does not explicitly mention a right to privacy, but in a number of decisions found a guarantee of certain areas of zones of privacy. So in other words, he's admitting that there really is no right to privacy in the Constitution, but there's zones of privacy. So he's kind of doing an end run around the truth here. In the Bill of Rights and in the 14th Amendment, which guarantees liberty, there are zones of privacy. Okay, I guess the uterus is a zone of privacy. And these involve marriage, contraception, family, and child rearing. So here you see contraception, right to contraception, which has only been founded in 1965. But here we are 8 years later, and it's already an established right. It's precedent. So it's sacrosanct. We can't influence contraceptive. Where did that come from? It came from Griswold versus Connecticut. Justice Douglas elaborated on the zones of privacy. He said these are fundamental to the concept of liberty under the protected penumbra of specific guarantees of the Bill of Rights. Again, we're stretching the Bill of Rights way beyond what it was ever meant to cover, because these are justices that believe that the Constitution is a living and breathing document that we can basically pull like silly putty to cover anything that we want it to. In the Pew Forum, where I got this information, Roe granted access to abortion as a fundamental right. Its only compelling state interest could justify enactment of state laws limiting that right. So there had to be a compelling reason not to abort. So it basically says abortion is it's the fail-safe. Abortion is the norm, and it has to be unusual to limit abortion. Basically, you can find an excuse to do an abortion throughout the 9 months of pregnancy by following the loopholes that were left behind. Justice Henry Blackmun created a 3-trimester of pregnancy concept. All right, he developed the 3 tiers, 3 trimesters of pregnancy concept. Okay, in the first, for legal reasons. All right, it was not developed for health reasons; it was developed for legal reasons. In the first trimester, that's conception to 3 months, the state has no interest in protecting a mother's interest, no interest in limiting abortion except to protect a mother's interest, i.e. to get the abortion, and also to provide health safeguards, although where they are, I'd like to know. There's virtually no limitation on abortion clinics. In a subsequent case, the state of Texas was trying to maintain that doctors needed to have hospital admitting privileges. Say a doctor who does an abortion leaves a woman with her uterus perforated and she's bleeding profusely. Well, that same doctor in the local hospital, when the ambulance takes the bleeding woman there, as we've witnessed in Hartford, we saw a woman leaving Hartford Women's Center, Hartford GYN Center, bleeding profusely. And that doctor could not follow her to Hartford Hospital. He didn't have admitting privileges. So it's very dangerous for doctors not to have admitting privilege. So I don't see how the woman's health is safeguarded. Also, the record of clinic inspections, the requirements for clinic inspections is very, very spotty, but whatever. So the state allegedly has interest in safeguarding the safe of the woman. From 3 months to viability. Now, what does viability mean? Viability means a baby can live outside the womb. Now, since 1973, that's gone down significantly. At the time, it was considered between 24 and 28 weeks of pregnancy, but thanks to advanced perinatal care, neonatal care, the baby can now live as early as 22 weeks. All right, so we've gone down quite a bit. But anyway, from 3 months to viability, which should be roughly 6 months, which should be 24 weeks, and that's the legal limit in Connecticut for abortion, the state can regulate abortion to protect a mother's health. Again, the mother's health, which they say they're so interested in, yet they never want to inspect abortion clinics. An MD can advise a woman on abortion risks. Oh, how generous. Abortion is the most common surgery in the country. You'll never see it on TV. You never hear it discussed. And women are unaware that they could jeopardize their fertility, their life, and in many ways their health, emotional, physical, and that's a whole nother show. But the doctor was not allowed to advise a woman in the second trimester of abortion risk, but he's not allowed to talk her out of an abortion. Interesting. Doctors can talk you in and out of any other kind of surgery. If anyone's ever had surgery, you know the doctor usually has an opinion on whether the surgery is a good idea or not. You're free to get another opinion, but I've never met a doctor who recommended surgery that didn't think it was good for you, of course. But no, the doctors have their hands tied, and many of them are afraid to have opinions regarding this. They're afraid of litigation. So viability. So at the age a baby could live outside the womb. Now, of course, that doesn't mean the baby's not dependent, does it? If you've seen a neonatal unit, you know that the babies have all kinds of tubes and wires attached to them for feeding, they have their environment controlled, they have their oxygen controlled, and their constant blood tests, constant monitoring by the wonderful staff of nurses. And they're very vulnerable to brain bleeds. They're vulnerable to because their lungs are immature. So they're very, very dependent. In fact, there's even research that is making artificial wombs so that these babies can be very much like they're inside their mother. So there's definitely a state of dependency, but they can live outside the mother's body. So that, according to Blackmun, does change things. So according to Justice Blackmun, the state has an interest in potential life, in protecting potential life. He puts that in quotes, and can ban abortion as long as it's allowed when the mom's health is at risk. Well, that's what we call in the pro-life movement an opening big enough to drive a truck through. Because define health, okay? Many women who want late-term abortions have said that it's mental health. In other words, if I have this baby, it will cause undue distress on me, and I cannot put myself through that stress. I've heard of one case where a young woman wanted to attend a concert and was heavily pregnant. I believe she's around 24 weeks. And being pregnant and going to this concert was going to cause too much stress to her. Not to say that there aren't serious cases, but the health of the mother can be stretched to mean almost anything depending on who you're speaking with. But it's very important to know that in the third trimester of pregnancy, there is an interest in protecting potential life. In the case of Doe, Blackmun said state regulations which provide procedural obstacles to abortion, such as an abortion has to be performed in a hospital, without getting to providing an undue burden on the woman. So there can be some state regulations in the third trimester. And if you look at the state in Roe versus Wade, those were the only restrictions on abortion. Were in the third trimester. It is the most controversial decision ever, Roe versus Wade and Doe versus Bolton, which were decided on the same day, but Roe is the one that is the most important. It does not allow parental consent. It does not allow spousal consent, and it does not allow waiting periods, Roe versus Wade. Those came later. Those have been introduced, thank God, but they were not allowed originally. The SCOTUS Supreme Court struck down the 1987 law in Webster versus Reproductive Health Services. That was a Missouri law which said no public facilities or workers will do abortion unless health of the mom is at risk. So they're not going to have abortion in public hospitals, and public workers don't have to do abortion. So little by little, we've been chipping away at Roe versus Wade by limiting when abortion can happen. But Roe versus Wade is a very broad decision that basically allowed a path to abortion throughout all 9 months of pregnancy. Again, in union with laws in North Korea, China, and Canada, the four most liberal abortion countries in the world. I don't know how you feel, but I don't want to belong to a country that has laws similar to North Korea and Canada. I mean, China. Well, Canada. Canada usually is more liberal than the United States. All right. According to this law, the doctors are supposed to do fetal viability tests at 20 weeks in an abortion-seeking woman. I've never heard of that ever being done. Fetal viability was done on my daughter with Down syndrome. We didn't know she had Down syndrome because she needed to be born at 35 weeks, and they did a test to make sure her lungs were functioning well. She was born at 5 pounds 4 ounces, which is technically not premature because she was only a month early, and she was not under 5 pounds, so she did need oxygen. But the prenatal viability test, which is what, by the way, what amniocentesis was originally developed for, because it can cause preterm labor, was to determine if her lungs were mature enough to breathe on their own, and fortunately were. And Judge Rehnquist in that case said that law's declaration that life begins at conception, that is in the Webster versus Reproductive Health Services, does not contradict Roe because it's in the law's preamble. That Missouri law that said life begins at conception does not contradict Roe versus Wade because that declaration is in the law's preamble. Talk about trying to win on a technicality. It is in the law's preamble. He said the right to abortion in Roe does not mean you have a right to government assistance in abortion. So that's saying that you don't have a right to Medicaid abortion. You don't have a right to say that this public hospital must perform abortions or this public health care worker must perform abortions. So there was a little bit of a limit to abortions there. Justice Kennedy, White, and Rehnquist dispense of the three-tier system, saying, "We don't see why the state's interest in protecting potential human life should come into existence only at the point of viability, and should be a rigid allowing state regulation after viability, but not before." So they sort of tossed out the idea of viability as being the dividing line between abortion being legal and not being legal. So the three-tier system is basically thrown out in that decision. The concurring opinion, Antonin Scalia, at the time, this is 1987, he was on the court, said the majority opinion was stingy and indecisive, and he felt very strongly that Roe should be overturned. All right, so he's saying that don't give me this law is only in the preamble of the law, so therefore saying that life begins at conception isn't true. He says, I agree with you that we should limit abortion from public institutions, but Roe should be overturned. Justice Sandra Day O'Connor said that the prenatal testing was too burdensome on women to find out if a baby was viable or not. She felt that created what they call an undue burden on women. So Justice Blackmun issued a dissent on that law. He described the written opinion as followed with winks and nods and knowing glances to those who want to do away with Roe explicitly. See, it's very dangerous when you create legislation because you also create a possible precedent for Roe to be overturned. That's what he's saying. He's very angry. He's very proud of Roe versus Wade, as he said when he retired. And he didn't want any winks and nods in this legislation to possibly give a way out of Roe. So we've been legislating the Supreme Court. We've been legislating, but the Supreme Court's been deciding about Roe versus Wade since 1973. It's been challenged many times, and if it is overturned in a future court, it would not be the first time it's attempted. So in June 25th, 1990, there was a case called Hodgson versus Minnesota, in which the judicial bypass of parental control sent rules. Okay, at this point, we were talking about whether minors could have abortions without their parents' consent. And this judicial bypass is if a minor girl feels that her parents would, let's say, throw her out of the house or beat her for having an abortion, she can go to a judge at any time, and the judge will probably grant her the right to have an abortion. Okay, here's the next most important Supreme Court case regarding abortion. Planned Parenthood versus Casey. All right, maybe if you heard about that. I remember walking by a car in 1992. I was pregnant after having been married 6 months before, and I saw a picture on Time magazine of Supreme Court Justice cape, or their black robe hung on a hook, and the question is Roe moot? In other words, is it finished? And my heart leapt, and being a lifelong pro-lifer and being pregnant, I was very excited about the possibility, but unfortunately, their hopes were dashed. Okay, Robert Casey was the Democrat pro-life governor of Pennsylvania at the time. In Planned Parenthood versus Casey, the Supreme Court reversed previous ruling preventing any state involvement in abortions. So states were given the right to limit abortions as they see fit. All right, in the first trimester, states were allowed to pass laws for waiting periods. For example, if a woman had a diagnosis of pregnancy, she had to wait 24 to 48 hours before making the abortion decision. It's always a good idea to think about surgery. There's always a risk for any surgery, but particularly for abortion. And we know that there are risks, even though the abortion industry tries to hide them and tries to keep them from media. But we know that women are deeply affected by abortion emotionally, physically, spiritually, in every way. So definitely every woman considering never mind the fact that it ends a human life, should always reconsider and not rush into anything in the heat of the moment. Or if they got a prenatal diagnosis of an infirmity with a baby, that should always have a chance to pray, to talk to their relatives, to talk to their spouse. And not just sneak off behind everybody's back and have an abortion. Many times young women are petrified when they find out that they're pregnant. They're afraid of their parents' reaction. And in many cases, when I was working in a pregnancy center, the parents ranted and raved when they found out because they had to face the fact that their daughter was sexually active, which many times they were in denial, and eventually came around and were the proudest grandparents you ever saw. In many cases, helped care for the child and certainly did not throw the girl out, or if they had thrown her out, they took her back in. So again, waiting periods were allowed, And there were requirements in some states for pre-abortion counseling. Imagine that, giving the woman informed consent before surgery. Well, I've had surgery a couple times in my life, and except for the emergency C-section, I was always given a list of possible side effects and possible the recovery period, what the chance of success was. It's always important to get that counseling before you have a choice like an abortion. It's essential. And anyway, so then states were also allowed to institute parental consent for minors. I mean, my daughters can't get their ears pierced or get an aspirin in school, but they can get an abortion. I met a couple of teachers from Manhattan that I live near in New York, and they were very upset that a father from the Dominican Republic was livid because they had taken his 14-year-old daughter for an abortion during the school day, and she just went home on the bus like anything else. And I guess it came out. I think the girl had some bleeding, and he was livid. And the teachers are absolutely confused as to why he would be upset that they took his daughter for surgery during the day without their knowledge. But it is legal in New York. It's legal in Connecticut. Okay, so Planned Parenthood versus Casey actually has helped reduce abortions. This is in 1992, and abortions were at an all-time high in the late 80s and early 90s, 1.5 million abortions in America per day. Now in 2018, they're down to half that, and a lot of the reason is these abortion restrictions. Asking women to wait, asking minors to tell their parents to get parental consent, or at least parental notification. That's different from consent. Notification means you tell your parents what you're going to do. Consent means they have to sign off on it. And, of course, the pre-abortion counseling. Once women know, for example, how developed their child is, they will often choose to have the baby. Unfortunately, even through our best efforts and sonograms being pretty widely known, many times when I was working in a pregnancy center and a woman saw her baby in the sonogram, she was shocked because she had had a test over at Planned Parenthood and they told her that baby was just a clump of cells. Just a note, Planned Parenthood and abortion clinics do sonograms for one reason and one reason only, so they can determine the method of death for the baby. What is the best way? Are they going to dismember the baby? Are they going to do scraping? Do they have to yank the baby apart piece by piece? Or can they do a medical abortion? That's a pill that the woman takes where she has the baby too early to be born at home, just like a miscarriage. She expels the baby at home in a week. So women are never allowed to see the sonograms in an abortion clinic. I set my daughter up to go ask for one in Planned Parenthood. She had a prescription for a sonogram, not for, she wasn't pregnant, but just for a different part of her body. And she said, well, you do sonograms, right? Can I have a sonogram here? And they gave her a very dirty look and said, no, we don't let the patients see them. So it's very clear that Planned Parenthood and independent abortion clinics are not interested in women knowing anything about abortion except what they're told by them. They look like they're compassionate and they're doing the right thing for the woman, but why would they be working so hard to shut down pregnancy centers, which outnumber abortion clinics, by the way, 3 to 1? Why would they be working so hard to call us fake clinics and to shut us down, saying we give fake information, if they were really interested in a woman making an informed decision? Why would they be so interested in women not getting information and suppressing pro-life speech, for example, on college campuses or in the media? You've heard perhaps that pro-life speech has been censored on Facebook and Twitter, and that people that are trying to show the realities of abortion have their profile blocked. It happened to me. I've tried to see some of my posts through other people's profiles on Facebook, and many of my pro-life posts are blocked. So if I wonder why I only have a couple of likes, it's because very few people are allowed to see them, as Facebook has determined that my pro-life posts are offensive. So certainly it's not for sexual content because they don't seem to have any problem with that. But anyway, in June 28, 2000, the Supreme Court had a decision called Sternberg versus Carhart, which struck down the Nebraska ban on partial birth abortion. And that was one of Justice Kennedy's pro-abortion votes. He struck down a ban on partial birth abortion. Can you believe that? Partial birth abortion, to be graphic warning here, if you have children, is when a baby is too big to be born alive during the abortion procedure. And the reason is because the baby might survive. So we have to to make sure that we dismember the baby in the womb before the head leaves the womb, because then it would be considered infanticide, which many abortionists were not against, Kermit Gosnell most notably, and Leroy Carhart among them. But partial birth abortion is when a baby is born feet first in a breech position, and a scissor is inserted to the base of the skull by the spinal cord and opened, and the brains are suctioned out. So the head collapses, and the baby is born brainless, and the skull is collapsed. So while the baby is being held, the head is being held in the uterus, the child is kicking and moving and very much alive, and very much can feel the pain of the brain being pierced and sucked out. The skull being pierced and the brain being sucked out. So this is a barbaric procedure. It's really no more barbaric than taking baby apart limb by limb, or having baby born early and suffocate on the table. But, the optics of it were very, very bad. And the advantage of this case in 2000 was that it was all over the media, and there were Senate hearings. A couple of times they had tried to pass a ban on partial birth abortion, and many debates on the House floor were very good opportunity for the public to have their eyes open on the realities of abortion. It wasn't a clump of cells that was being removed from the uterus. It was a living, breathing, well, not breathing, but living, thriving baby. In most cases, a healthy baby that was being brutally killed without any kind of anesthetic or any regard for their life. So, November 5th, 2003, President Bush passes the partial birth abortion ban. He signs it in 2003. So the Supreme Court had struck down the Nebraska law with a lot of struggle over the next 2 years, and fortunately, because he had a Republican Congress for the first time in a long time, he passed the partial birth abortion ban. And it was held by the Supreme Court in 2007 in a decision called Gonzalez versus Carhart. So there was Leroy Carhart, just like Bill Baird. Leroy Carhart was a late-term abortionist who started with the infamous George Tiller in Wichita, Kansas, and now is in Maryland. It was also Planned Parenthood Federation of America was also involved. So it was Gonzalez, Carhart, and Planned Parenthood, three complainants in this decision. But anyway, so partial birth abortion was banned. Everybody was happy about that, but the reality is that there's always another way to kill an unborn child. So although we were outlawing one specific procedure, we really have our doubts whether that saved any lives. So what it did do is that it educated the American public that what is actually going on in many cases is just out and out infanticide. So up to Planned Parenthood versus Casey, Roe versus Wade has created here was the justification for not overturning Roe. Roe has created an expectation of legal abortion which cannot easily be discarded. Well, we must respect a woman's expectation she can have an abortion. Why does she need an abortion? Because contraception fails. Most of the people I saw, the women I saw in a pregnancy center over the years, were there because the contraception did not work. In one case, it was an IUD that did not work. All right, so anyone who tells you the contraception is 100% effective doesn't know what they're talking about. So since Planned Parenthood versus Casey in 1992, states have enacted 300 or more abortion restrictions limiting abortion. They're 50% of what they were in 1988. Why? Because women are given, in most cases, women are given information. Okay. Fetal pain laws have been considered by 9 states trying to prohibit abortion at 20 weeks or earlier when allegedly a fetus can feel pain. The pain receptors are developing all along, so we're not really sure at what point they kick in. I don't think there's one day that they switch on like an electric switch, but 20 weeks has been considered by legislators anyway as a standard is when babies can feel pain. All right, this ban on abortion after 20 weeks, the fetal pain laws, was not passed in the U.S. Senate. It was passed by the House, but it was not passed by the Senate last year because of Susan Collins of Maine and Senator Murkowski of Washington. They would not ban abortion because of pain after 20 weeks. So there have been various states that have banned abortion for Down syndrome or for sex selection, but we know that it is definitely not going to be easy to overturn Roe versus Wade. But let me make it clear, overturning Roe versus Wade does not ban abortion in every state. I believe it would ban abortion in about 20 states. There would still be a state-by-state battle in many of the blue states, the liberal states like California, New England, the East Coast and the West Coast, where abortion would be brought to the state level. And would be decided by the states. So Roe versus Wade is just the beginning of, what did they say? It was the beginning of the end, not the end of the beginning. It would just be a beginning for us to start to look at abortion state by state. So I attended online a webcast regarding this week's decision of NIFLA versus Becerra. All right, and we were talking to the Alliance Defending Freedom in NIFLA. Basically, what they said is that NARAL and Planned Parenthood have been trying to shoot down crisis pregnancy centers, and they have a law in California where a woman, the pregnancy center had to post an 8x11 notice in a very large font in 12 different languages, telling women how to get an abortion in a pregnancy center. Now, an abortion clinic never has to tell you about pregnancy centers. In fact, there's a notice in pregnancy centers very often in abortion clinics lying about pregnancy centers, saying that we give misinformation. But we were going to be forced, California pregnancy centers were going to be forced to inform the women about abortion. And that worked its way all the way up to the Supreme Court in NIFLA versus Becerra. Becerra is the Attorney General of California, who is arguing in favor of the law. So the real question was free speech. Can churches be forced to speak in favor of abortion, churches and abortion clinics? That was the real question there. In Hawaii, there's a crisis pregnancy center inside a church, so therefore a church was involved. So it's very important to understand that this was, can pro-lifers' free speech be limited? And it's very important to notice that. The law involved licensed medical clinics to post a sign in the lobby, and non-licensed had to have a disclaimer saying where you could get an abortion. It was basically a billboard, because if you had to do a 48-point font, a 29-word disclaimer in 12 languages, you basically have to wallpaper your clinic, your pregnancy resource center, with a pro-abortion notice there. So it's very important to listen to what Clarence Thomas had to say about this. And I'm almost ending here with this. The so-called learned professions, acting in their professional capacities, are among the most valued participants in the marketplace of ideas. It is one thing to require professionals to exercise due care and competence in the provision of their services. It is quite another thing entirely to draft them to advance the ideological priorities of an activist state. By requiring pro-life professionals to advertise for free abortions, the state uses its immense power to undermine the very purpose of their professional work. Justice Clarence Thomas, the majority ruling in NIFLA versus Becerra. So it's very important to know that professionals cannot be forced into pro-abortion speech because the state feels that that's a good idea. So it was a First Amendment ruling. It was also a pro-life ruling. And it's very important because this will go back to the states to stop laws, including there was one in Connecticut against the pregnancy center I ran for a couple of years called Hartford Women's Center. Hartford City Council had enacted an ordinance which would have limited our ability to advertise. But they said that the law would not take effect until today, July 1st, because they knew that the Supreme Court could overturn the law, and they didn't really want to get involved in a long court battle over something the Supreme Court could just wipe away, as the Supreme Court did. That ordinance and many other ordinances around the country were just made null and void. But don't be fooled. The NARAL and the abortion industry will be back trying to stop pregnancy centers, because we and the abortion restrictions have undone some of the damage of Roe by converting hearts, by showing women that there are alternatives to abortion, they're not alone, and that we will walk with them through the entire birth process and many years after, helping them with support, with resources, with direction to resources in the community, and with spiritual and emotional support will help them bring their child to birth and to carry that child. But what this did do is it kicked NIFLA versus Becerra, is it kicked the hornet's nest. NARAL is infuriated, and governors are promising to get us and to sue in response to the Supreme Court ruling. So basically the fight has been joined, that this ruling has protected the free speech rights of pregnancy centers, and the fact that Justice Anthony Kennedy has resigned from the Supreme Court, effective, I believe it was yesterday. So the swing vote in the Supreme Court is now up for grabs. It may go to a conservative. President Trump has a list of 25 justices, all approved by the Federalist Society and the Heritage Foundation, two conservative think tanks. They're all originalists. I believe that they're all against Roe versus Wade. So you're about to see the fight of your life coming in front of our television sets, because Trump has made it clear he will nominate and have approved by the Senate his nominee before the midterm elections in November of this year, November 2018. So we're talking that first there will be some hearings in Judiciary Committee. They will make a recommendation, and then there will be a vote on the Senate floor. And again, we have Senators Collins and Murkowski, women senators that are pro-choice. They may not be able to be counted. And also Senator John McCain is too ill to sit and vote in the Senate. He would probably be a pro-life vote, but he has brain cancer that he's dying of, and he has not relinquished his seat. So another pro-life Republican cannot be put in his place. So keep your seatbelts on, folks. Things are about to get very interesting in the Supreme Court. Hopefully my next segment on the Supreme Court, next week, I will have a guest speaker who knows more about the Supreme Court and can fill in the blanks that I've left here. I just want to thank you for being with me for this broadcast, and I look forward to talking with you next week on Living the Gospel of Life.
We hope you enjoyed the program and will join us back for another show on WCAT Radio. This is Sebastian Mahfood. Good day.